I, Stephen Yaxley Lennon, alleged contemner of an address known to the court in Bedfordshire, make oath and state as follows. The matters described in this statement are within my own knowledge, except where stated otherwise, and are true. Where I refer to matters that are not within my own knowledge, I state the source of my information and believe them to be true. I believe all the information in this witness statement to be true and accurate as of the 4th of June 2019. I make this statement in defence of my committal for contempt of court. I was convicted of breaching a Section 4 reporting order. After spending nearly 3 months in solitary confinement, which has left me with long-term mental health issues, the conviction was quashed at the Court of Appeal because the Lord Chief Justice found the original trial was completely flawed.
And allow the appeal against that finding for the detailed reasons set out in the judgment, essentially because the process was flawed.
When I came back last November to face a retrial, the Attorney General had added 2 additional charges. Suggestion that the content of my live stream was prejudicial to the case, despite the fact that in the event the Akhtar case was completed, the verdicts were reached by the jury. I responded to these additional charges and stated clearly that in the transcript from the original trial, the judge discussed my video with Mr. Wright from the Crown Prosecution Service. Having reviewed the content of my full video, Mr. Wright was referring to the jury when he stated in court that there is nothing they could have seen that could in any way prejudice him against the defendants. Judge Marson agreed with this. I believe this was confirmed again at the High Court last November. Given that 2 separate courts had already decided that what I had said could not have been prejudicial to the case, I now see that the Attorney General has decided to remove those charges. Having removed these 2 charges, the Attorney General has now decided to add 2 different allegations on top of the original allegation of a breach of a Section 4 reporting order. These comprise a strict liability contempt and a common law contempt, which both appear to suggest that by questioning and photographing the defendants on that day, it could have led them to feel anxious and therefore not be in the right frame of mind to enter court and participate properly in the proceedings. How are you feeling about your verdict? How are you feeling about your verdict?
What verdict?
How are you feeling about the verdict? You got your prison bag with you?
Yeah, look at you.
Got your bags with you? You got your bags with you?
Yeah.
How are you feeling about the verdict?
Oh, I suck your mum's fanny.
Yeah,
You
come
little
on.
muppet.
You got no guilt. Is there any guilt? Is there any guilt, mate? Is there any guilt?
Fucking dad, you son of a bitch.
It also states that by merely photographing them while entering the court, I have committed contempt of court under common law. The Attorney General sat on this case for over 5 months, and the very week I released my documentary Panodrama, exposing how the establishment is complicit in trying to set me up and publish lies about me, I was deleted from all social media, and the government also decided to bring back this case to the court as they believe the significant expense of this trial is in the public's interest. In relation to the first allegation, breaching the order of the court, I say as follows. Firstly, I would like to assure the court that undermining the court, its authority, or interfering with the administration of justice was never my intention. I acted in good faith within the parameters of the Section 4 reporting restriction in place. The information I provided was in the public domain. It was factual and relevant, but did not provide any details of the trial's proceedings, other than what had already been reported previously, readily available online. When I arrived at Leeds Crown Court that morning, I could not obtain any specific details of the reporting restriction order. I do not believe there is a website which holds such details, at least I have not been able to find one. So I researched online and reviewed the reporting restriction guidelines provided, which can be found here. They state that the court should include details of reporting restrictions on the court listings, both online and in court, and also provide a notice on the door of the court. The Attorney General has now confirmed this in the details of the committal application, where James Jenkins, in his affidavit which accompanies it, at point 10 states that no such notices were displayed that day. The fact that there was no evidence that the reporting restriction was still in place led me to believe that the jury were out, the reporting restriction may have been lifted. The only time a notification about any reporting restrictions was available was later that afternoon, after the court had convicted me and sent me to prison. Only then did the court follow the judiciary guidelines and list a reporting restriction against the court's listings for both the grooming case and my subsequent case. Only then. After my previous experience with contempt of court in Canterbury, I went out of my way to ensure I would not fall foul of the law again. I privately paid for training with one of London's leading law firms, Kingsley Napoli, to cover all details regarding contempt of court. I was a citizen journalist. I hadn't practiced or trained, so I made mistakes in the early court case. I wanted to learn. I didn't want to fall foul of the court again, so I paid for my own training. On that morning at Leeds Crown Court, I had knowledge of the verdicts of the first phase of the grooming trial and many of the specific details discussed in court for this particular trial. Despite believing that the restriction may be no longer in place, due to the absence of any formal notices on the website, the court screens or the door of the court, I decided not to talk about these specifics in my live stream on that day. My understanding, based on my training, was that the specifics of the case and the verdicts were off limits for reporting restrictions, so I decided to err on the side of caution. I went into court to ask someone if the reporting restrictions had been lifted, and the individual I spoke to said he did not know anything about a reporting restriction. Having been unable to obtain any details from the court, I decided to refer to the guidelines for reporting restrictions on the judiciary's website. The judiciary's website. Exhibited above, which I found as a result of my own research after my contempt training. The guidelines are a practical guide aimed at judges and the media on the statutory and common law principles that should be applied with regards to reporting restrictions. In this paper, it states that the courts have no power under Section 4 of the Contempt of Court Act 1981 to prevent publication of material that is already in the public domain. They have no power to do it. I followed my training and this guidance to the letter. I did not divulge any of the previous case verdicts. I did not detail any of the specifics mentioned in the trial. I did not assume guilt and refrained from entering court property. I even asked the officer outside the court about where the boundary line was. I then asked the officer on video if the location I was filming was okay. He confirmed it was. I also followed the guideline statement that I could reference information that was already in the public domain, because this couldn't be part of a restriction order. The law says it can't. Every single thing I said that day was already in the public domain. I actually read charges and names of the defendants from a BBC article, which to this day is still live on their website, as you can see here. I also did my best not to film anyone other than the defendants. I was calm and respectful throughout. Everything I said in the live stream that morning was fair and accurate and published in good faith within the constraints of the judiciary's guidelines for the media. It is my understanding that there's been no individual in the last 60 years to be sentenced to prison for a publication breach of a reporting order. It would appear that my committal was truly exceptional. The court's failure to follow its own guidelines and notify the public about the reporting restriction, combined with the fact the jury had retired, led me to believe that the reporting restriction may have been lifted. Despite this, I still followed the guidance from the judiciary's own website to ensure that I did not breach any potential reporting restriction if it was still to be in place. My contempt committal was later found to be completely flawed. The punishment handed down to me was extreme. Every other entity which has breached an order in the last 60 years has only received a fine. The journalist Rod Liddell was writing for the Spectator magazine in relation to the Stephen Lawrence murder trial in a way which was found to be contempt. It was prejudicial. Not what mine was, prejudicial. When the Spectator was sentenced for breaching the Section 4 reporting order and risking prejudice to the trial, it was given a fine. Journalists at the Daily Mail and the Daily Mirror published highly prejudicial material on the trial of Levi Bellfield, who abducted and murdered an 11-year-old child. This contempt of court led to the collapse of the entire case, a discharge of the jury, and robbed one of the victims of the chance for justice. The reporters in this instance, they weren't prosecuted. Instead, their employers were found guilty by contempt and fined £10,000. They weren't sentenced to prison. No one's been sentenced to prison ever for this. None of my reporting was prejudicial. We've established that. 2 separate judges have confirmed that. I have reviewed the transcripts from Leeds Crown Court where the judge was discussing various reporting order breaches. The judge and the Crown prosecution discussed the fact that multiple news sources breached the very same order placed on my trial, with some breaching both the reporting orders, mentioned in the grooming trial as well as my arrest and prison term. The court transcripts state that Lizzie Dearden, the Home Affairs correspondent at The Independent, actually refused to remove her article when contacted and provided with the details of the order. Instead, she stated that the effect of social media voids reporting restrictions, so she couldn't be held in contempt of court. The Crown Prosecution Service and the judge agreed that these were indeed breaches of the Section 4 reporting order and were a matter for the Attorney General to review. When I was informed in court that there was still a blanket order in place, I apologised. I offered to delete my video immediately. Despite the multiple breaches of the order by different newspapers, that same weekend the same law broke that they're alleging I broke. The flat refusal of Lizzie Dearden to take her own article down. Not one of those journalists or the editors of those publications have ever been arrested or prosecuted for their breaches of the Section 4 for the Contempt of Court Act. According to the court transcript, the newspaper breaches of the reporting order was a matter for the Attorney General. My case wasn't referred to the Attorney General for review. Instead, I was hauled into court immediately. I was refused my own choice of legal representation. I wasn't even asked to plead guilty or not guilty. I was prosecuted and convicted in a matter of minutes in what the Court of Appeal regarded as a flawed trial. I was then imprisoned for over 2.5 months on solitary confinement, held against my categorisation, moved to the highest Muslim population CCAT prison in Britain, subjected to mental torture and constant threats and abuse, and had all of my rights removed in the interest of prison safety, as detailed in my earlier affidavit relating to the application for committal. Even after my release, my case was not referred to the Attorney General to review, as is normal procedure. It was only referred to the Attorney General by the head judge at the criminal court, who decided that he would not hear the case back in November after I had submitted my witness statement detailing the course of events on that day. I took what I genuinely believed to be all reasonable steps to determine the terms of the Section 4 order, and that I actively sought not to breach it, unsure whether it actually was still in place or not whilst I was reporting. It is clear to me and anyone watching these proceedings that my continued prosecution, relentless persecution, and use of heavy-handed tactics by the state is solely because of who I am, rather than what I did. If the court chooses to find me guilty of breaching the order, they should also arrest and convict the other mainstream media journalists like Lizzie Dearden, who, as per the court transcripts, knowingly breached the same order that weekend, but went further and refused to take down their article when contacted. The Attorney General has added 2 further charges to the original charge of breaching a Section 4 reporting order. The Attorney General has provided the following basis for these additional charges. Substantial risk that my video would be seen by the defendants. The Attorney General alleges that my supporters would take my invitation to harass the defendant. The Attorney General states this would create distraction and anxiety to the defendants, which may impede their ability to participate properly in the trial. I completely reject the Attorney General's assertion that I incited my followers to harass the defendants. This is completely false. It's a lie. I even say you want to stick pictures online and call people and slander people. How about you do this to them? That is specifically talking to the press who do these things to me. It's not inciting my viewers to do that. I was making the point in my live stream about the double standards of the press and the media. The Attorney General does not include the words in the transcript before, which deliberately portrays the words out of context. I'd just been discussing the press treatment, provided an example where they have harassed a young man and his family for speaking out against these cases. I also mentioned that I have received this press harassment for years. I was never on such heinous charges as child abduction, rape or prostitution. By way of example, when I was released from solitary confinement in prison, I was malnourished and left with serious mental health issues. I went away with my family to try to reconnect with my wife and my children and recover from the trauma and treatment by the prison service. The mainstream media and press hounded me. They turned up at my mother's home. They knocked at all my neighbours' doors asking questions about me. They even checked into a hotel I was staying in on holiday and photographed my children and continually accosted me for interviews in front of my children whilst I was trying to recover.
Have you me? You're here to take photos of my family.
I haven't taken photos
yes, you
of
have.
family. I've
You're
taken
journalist,
pictures of you.
No, you've taken them.
I haven't taken pictures
yes,
of you.
Yes, you just said you have.
The pictures, there are pictures of you.
You said you've taken pictures of me.
Yeah.
You just said that.
No, I haven't taken. But
that's what you just said.
I say we, I mean the group that I work for.
Oh, the group you work for. Yeah. You've come all the way out here to disrupt my family's holiday. Yes, you have. You've come out here so you can take photos and endanger my family.
No, I don't. It's not endangering your family.
Yes, it is. Why, you're here. You're taking photos of my family.
I haven't been taking pictures of your family. We've been taking pictures of you out and about.
Out and about.
I'd experienced this type of treatment month upon month by the time I was filming at Leeds Crown Court. During my entire activism, I've been hounded and harassed by the media. For the Attorney General to suggest I was inciting my followers to harass these men is a completely false allegation. I find it very difficult to believe that, given the intelligence of the people prosecuting me, that this could have been an innocent misreading of the transcripts. Have a watch here of the media hiding in bushes just recently. What's that? Yeah.
So I just spoke to the policeman.
Yep.
He said that he's going to be down here. I don't know. It's not an emergency, so they're going to come down here.
Yep.
When they can. I'm happy to verify myself to them.
Just verify who you are and I'll leave you alone.
That's fine. I can verify. Yeah, it's fine. I can
Just want to know. I just want to know why you're. Obviously, simple question. Why you're. Weird thing to see. Someone sneaking through bushes with a long lens camera, taking photos of me from a mile away, and then legging it when we clocked you. How long you been doing that? Who funds you to do that?
It's not answering these questions. It's
No?
just ridiculous.
No, it's ridiculous. It's ridiculous. The man who's hanging out of bushes with long lens cameras following people around thinks it's ridiculous when they're asked a question. Camera?
In the event, many of my supporters did pop down to say hello at the court. They were polite, none of them acted in an aggressive manner or looked to harass anyone. The evidence in the video clearly shows to the contrary of the allegation the Attorney General has put forward. The court has a duty to the victims and the public to protect them. By informing the public, it could help stop ongoing child sexual exploitation and prevent future vulnerable children from falling victim to it. I had been informed by some worried parents that one of the now convicted child rapists that was out on bail during the proceedings was still working in a fast food outlet and he had regular contact with children. Is it right that someone who has been charged with allegedly raping children should be able to work in an establishment that continues to provide him access to children? This is what real journalists should have been investigating and, if true, reporting about. My question was specifically directed towards the press, asking them why they were not investigating these defendants in the same way they'd done up until 25th of May 2019, and which, as illustrated above, they've continued to do after my release from prison. I truly believe the reporting restrictions on this trial and subsequent connected trials are detrimental to the public and should be lifted as a matter of urgency, so the public can hear all the details and use the knowledge of these proceedings to help prevent further cases such as these coming before the courts. The jurors are given a responsibility. They're aware of the consequences of researching the cases they sit on. It should be upon them, and we should trust them to do the task with honesty and integrity. It should not be for the British public to be kept purposely in the dark just in case they don't. In any event, reporting was fair and accurate, published contemporaneously and in good faith. The common law point is that by questioning the defendants on camera, they know that the recording would likely be made available to the public, which would leave the defendants in an anxious state and not be in the right frame of mind to participate fully in the trial which had ended. The Attorney General states that it disrespects the administration of justice, which requires that persons who are required to attend court should be able to do so without the hindrance or fear of molestation. Yes, they actually used the word molestation. The men who are in court for molesting young children. This isn't a joke. The Attorney General also points out that merely taking photographs of the defendant entering court and publishing those photos is an administration of justice offence contrary to Section 41 of the Criminal Justice Act 1925, and in the circumstance of this case, contempt of court under common law. My behaviour in relation to this allegation must be compared to the behaviour of other reporters, both towards me once I faced these contempt proceedings in their many guises, and also towards other defendants subject to allegations of some similarity to those which were the subject of the ACTA trial. Every time I've been to court, I've had journalists approaching me, hounding me with hostile questions. I've been verbally abused by hundreds of people. None of these people, neither journalists nor members of the public, were taken into custody or brought before a judge for contempt proceedings. The reason for this is such behaviour does not satisfy the test for common law contempt. Indeed, the naming and filming of defendants in similar trial continues. The reporting on the latest grooming case prints their name and their address and charges whilst they're still in court. This is no different to what I did. No different. It even gives their addresses. If the Attorney General wants to commit me on common law contempt for court for publishing photos of defendants entering court, surely they should also commit the reporter of the Huddersfield Examiner. Little girl groomed, raped and abused by multiple men, the court told. Now, watch this as this is what I'm in court for.
Lads, how you feeling? How you feeling about your verdict? How you feeling about your verdict? How you feeling about your verdict? What verdict? How you feeling about the verdict? You got your prison bag with you? Yeah, look at you. Got your bags with you? You got your bags with you? Yeah. How you feeling about the verdict?
Oh, I suck your mum's fanny.
Yeah,
You muppet.
you got no guilt. Is there any guilt? Is there any guilt, mate? Is there any guilt?
Fucking dad, you son of a bitch.
Now watch Lucy Manning. Lucy Manning is the BBC's main political correspondent.
So are you finally going to face justice for potentially collapsing this trial?
I didn't potentially collapse any trial. I'm actually not in charge. I'm not on trial for potentially collapsing a trial. My charge is causing anxiety to the men walking into court by putting cameras and asking them questions. Exactly what you've just done to me is what I face contempt of court for. Exactly this. Do you think this is causing me anxiety? Look at your actions. That's what I'm facing trial for. I didn't act this way.
Do you think it's right that you finally face justice for these charges?
This is a facade. The whole public know that. That's why the public are here to support me. No, I didn't nearly collapse. That's a lie. You're lying. You're lying. I didn't nearly collapse. The judge's words in that case, nothing I said could have caused prejudice to jury. Nothing. That's the judge's words. That's the judge's words. Read the transcript. Do your job as a journalist.
Were you in contempt of court?
No, I wasn't. That's why I was released from prison. The whole case was unlawful. Now, this is politically motivated persecution by a government who want to silence me. That's what this is.
What do you think about the fact they brought these charges back?
I think it tells everyone the fact. Look at what's happening here. Can you see this? Look, I'm in court for causing them anxiety. Look at all these cameras, look at all these journalists. She actually assumes my guilt in that video. There's no difference in what happened there. I'm not arguing that Lucy Manning should be convicted and tried. I'm saying that that's journalism. Both counts are journalism. Look at Rolf Harris walking into court. Now have a look at this. If I am convicted for taking a picture of someone as they walk into court, for asking a simple question, if I'm convicted, it will set a precedent that will make it illegal for you. So mainstream media, you should stand behind me on this. This is really a case of free speech and journalism and free press and the right to ask someone a fair question. The Attorney General appears to care about the possibility of the now convicted child rapists having anxiety because they were photographed. He has clear medical evidence of the mental health issues and severe anxiety that I now suffer from due to the inhumane treatment and solitary confinement at the hands of the prison service. Medical evidence that says clearly my mental health will be impacted further by these trials. But he doesn't seem to care about real, actual anxiety and mental health inflicted by the state, and instead believes this trial is in the public interest. Now this is an embarrassing thing to talk about, and Tyson Fury, by him, a great man like him talking about mental health, I think people should be able to admit when they're not right and when they need help. I come out of prison a different person than the man I went in. This is, when he talks about anxiety, these are all drugs that have been prescribed to me to deal with an ongoing issues and problems inflicted on me by the Attorney General's government. But yet he seems to care about the perceived anxiety that might be caused to a child paedophile. They know full well the implications of these trials and my subsequent imprisonment of solitary confinement. They know exactly what they're doing. Forgive me for not accepting that you actually care about anxiety or mental health. Judge Marston caused the video to go viral by locking me up in such an obviously rushed and illegal way. By placing a further reporting restriction banning any mention of my conviction, it It's what led to worldwide media attention. The reason this video was viewed across the world was because of Judge Marston's actions. All of the information I shared was already in the public domain. I was reading the charges and names from a BBC News article that was live on their website. The names and charges were also listed on the court public website. You can go online, go on their website, you can read all the names. Everything I read was in the public domain. You've already read that the law says the judge can't prohibit the reporting of that. Throughout my reporting, I clearly said they are alleged to have been involved, and all of them are innocent until proven guilty. Now, where I was talking to passers-by, I was speaking general terms about these grooming cases in general, not this specific case. As you can see, look in the newspaper article. On a grooming trial, there was another grooming trial, and the men's friends, the Muslim men's friends, shouted that they would rape the prosecutors, the female prosecutors. Now that doesn't get you taken to court. That doesn't matter. That doesn't get you prosecuted. Me saying they will have their prison bags, that doesn't assume guilt. It merely highlights that they are the defendants. I made it clear they're innocent until proven guilty. Every defendant has to bring their prison bag in case they are found guilty. I've had to say goodbye to my children and bring my prison bag 3 times already on this one case. The fact that I mentioned that was a strange response does not mean I'm saying they are guilty. I just thought it was pretty strange that each of them responded to questions about their trial by using aggressive sexual remarks about women. Now knowing that they are convicted child rapist monsters, it probably does make more sense that their initial response was vulgar, aggressive sexual comments against female members of my family. I treated the defendants with respect and in a restrained manner in comparison to the treatment of Rolf Harris and other high-profile cases with media scrums, such as my own. Lucy Manning of the BBC accosted me in a far more aggressive manner at my last court appearance, as can be seen in this video.
Are you going to face justice for potentially collapsing this trial?
I didn't potentially collapse any trial. I'm actually not in charge. I'm not on trial for potentially collapsing a trial. My charge is causing anxiety to the men walking into court by putting cameras and asking them questions. Exactly what you've just done to me is what I face contempt of court for. Exactly this. You think this is causing me anxiety? Look at your actions. That's what I'm facing trial for. I didn't act this way. This is a facade. The whole public know that. That's why the public are here to support me. No, I didn't nearly collapse. That's a lie. You're lying. I didn't nearly collapse. The judge's words in that case, nothing I said could have caused prejudice to jury. Nothing. That's the judge's words. Read the transcript. Do your job as a journalist.
Were you in contempt of court?
No, I wasn't. That's why I was released from prison. The whole case was unlawful. Now, this is politically motivated persecution by a government who want to silence me. That's what this is.
What do you think about the fact they brought these charges back?
I think it tells everyone the fact. Look at what's happening here. Can you see this? Look, I'm in court for causing them anxiety. Look at all these cameras, look at all these journalists. She asked me, do I think it's right that I'm finally going to face justice for these charges? And references that I nearly clapped the trial, which is completely untrue. By saying that I'm going to finally face justice, she is directly implying I'm guilty. She stood in front of me when I tried to enter court and was accompanied by multiple other reporters and cameras who were each jostling me and surrounding me in a scrum. This can be seen in the video submitted to the court. It was far more intimidating and aggressive than the 2 questions I asked the defendants back in Leeds. If the Attorney General believes that asking defendants questions may lead to them feeling anxious, for which he must bring a contempt of court charge, then given the law should be equally applied to everybody. I expect the arrest and committal of Lucy Manning, who's sitting next to me now in court. I expect the committal of every other journalist who accosts me at every court appearance. That is, unless this is a politically motivated charge that he's decided to apply a different treatment to me in comparison to everybody else in the UK. At one point in my video at Leeds, I make the point that I'm not showing someone on camera as I do not know if they're part of the trial. The Attorney General claims I suggested it was significant that they all responded with sexual abuse. I simply repeated what they said to me and said that I was a little surprised that on questioning 3 people about their case. I questioned 3 separate people about their case. 3 out of 3 had responded with aggressive sexual references. It was not what I was expecting, which is why I said it was strange, not significant. I didn't say it was significant, I said it was strange. In those circumstances, the defendants were committing public order offences, not me. The defendants' names and addresses were already out in the public domain. They're still present on newspaper websites and even the BBC website, which I would argue has a far bigger reach than me. Their photos were already in the papers and the BBC News. They had already been filmed at Magistrates Court. Their images were everywhere, their names were everywhere. Have a look at this now, look, you can see it. Again on the Examiner Live. I am photographed by every mainstream media outlet when I enter in court. Every time I enter a court, they take photos of me. Are the prosecution suggesting that this would lead me to be anxious and not in the right frame of mind to make decisions and answer questions for my legal team? That's what they're suggesting here for these defendants, you know, the Muslim rapists. Are they being treated differently to everyone else across this country? The allegation is that the Facebook video was only deleted when Judge Marston made a request to formally have it removed. It's incorrect. It's a lie. I immediately volunteered to remove my video the moment I was taken to court. I had followed the advice on the judiciary website, so did not expect to be in contempt of court. This shows I was cooperating. Judge Marston did not request that I remove it as this would suggest. The judge implies I was aware there was a reporting restriction in place in respect to the act of trial. This is not actually correct. Going into the trial, I'd heard there was a reporting restriction. I was under the impression the trial had now finished and we were just waiting for the jury to make their verdict. I was still fearful of falling foul to contempt of court, despite there being no notifications that the court order was still in place. So I decided to only mention information that was already in the public domain, because I didn't want to breach any potential order that may still have been in place. I went into court, as soon as I got to Leeds Crown Court, I went into court to ask someone if there was still a reporting restriction. They did not know anything about a reporting restriction, as is in the witness statements, as he's here to testify in court. I then checked on the court website online and it had no mention of a reporting restriction against this case, which is the procedure if there is one. That's what has to happen. If there is a reporting restriction on the case, it is also procedure to put a notice on the door of the court and on the screens in the court. So, it's so to inform the public or reporters. My colleague went into court to check the door and the screens and there was no mention of the restriction being posted. This gave me the impression that the restriction was no longer in place as the trial had finished and the jury were out. The guidance document on the judiciary's website states that there is no power to restrict information that's already in the public domain. It's for that reason that I only read the charges and the names from a BBC News article which was already in the public domain, live on their website for the whole world to see. As laid out, I believe I showed more than responsible steps to ascertain if the reporting restriction was lifted. It is actually the court who failed to follow the judiciary's own guidelines which has led to this confusion in the first place. I went to ask someone in court who did not know. I checked the screens. My colleague checked the court doors and I checked the court website, all of which failed to show that a reporting restriction was still live on this case, which goes against their own court guidelines. As I had not had verbal communication from the court, I decided that I would still not discuss the actual case to avoid any difficulty on contempt. I read information that was already in the public domain and as per the paper on the judiciary website suggested that once in the public domain, it can't be restricted. I presume the defendants have previously read all the newspaper stories discussing their charges, listing their names, their photos, even their addresses. I'd imagine they would have also already read the BBC article that detailed the same information that I did. None of the defendants were harassed, so quite clearly the risk was non-existent rather than substantial as the prosecution are making out. If the Attorney General suggests that it is contempt of court if the defendant cannot attend court without hindrance or harassment, then I would suggest he would need to arrest every single mainstream journalist who has just jostled and harassed me today, this morning, as I've walked into this court. He might also want to arrest the Antifa protesters with their megaphones shouting Nazi at me as I've again walked into court. This is far more intimidating and likely to cause anxiety than me filming a live stream on my phone on my own, asking simple, polite questions. Now, the allegation that one of the men on bail might fail to attend in the subsequent days because of the video I've taken, or because of their fear of being harassed by followers of myself after watching the video. That's the allegation against me. It is wild speculation on what might have happened and is based on this false allegation that I was inciting my supporters to harass the defendants, when the transcripts clearly show, the court transcripts, what I said. You've all watched the video. It clearly shows I was posing the question directly to the press in order to highlight their double standards. The contents of the video would not have led any of the defendants to fail to attend. None of these theoretical what-ifs scenarios actually happened, which shows how the risk is being grossly inflated by the Attorney General. This case involves seriously dangerous men with substantial evidence from multiple witnesses alleging rape and prostitution. Amazingly, Judge Marston decided that these men, they're not a risk to the public, and provided every one of them bail. One of those defendants took that opportunity and left the country for Pakistan, and has so far escaped justice completely. The only decision that has led to justice not being served in this case was Judge Marston's decision to grant these dangerous child rapists bail. Again, my experience entering court is far worse than the questions posed to these defendants on the day. Newspapers run lies and call me far right, extremist, and some have even called me a Nazi. All of the smears come from zero evidence or justification. This common law contempt has never been followed in any of my court appearances or any other high profile trials, so it would appear that the Attorney General has decided to take a different approach to myself than every other person and journalist in the UK. If taking photos of people entering court really amounts to common law contempt, then I will await the arrest of every single mainstream media editor who's ever posted pictures of me online today. Every one of them. I'm probably all over the press already, walking into court. So let's just summarise this. In fact, one other important bit of information which you can read here. The Law Commission in 2015, who were asked by the Attorney General to do an in-depth study into contempt of court laws, found that the laws are unfair, found that we could have serious errors where journalists couldn't find out information about reporting restrictions, or members of the public, like citizen journalists like me. Now, what the Law Commission advised, their sole recommendation after a 6-month study, was that the government need to have one single website that members of the public and journalists could go on and they could read the exact details of reporting restrictions. The government decided not to create a website. They ignored all recommendations of the Law Commission. So there was no website that I could go on as a citizen journalist. I went into the court as backed up with evidence by the members of staff in their statements. I tried to ask about reporting restrictions. I then sent my colleague in. We have photographs of the screen and the door. No mention of reporting restrictions. I went on the court website where, according to the judiciary website, it has to say that there's a reporting restriction. We now have evidence from the court that at no point were these reporting restrictions ever put into the system. The judge issued them. They were never put into the system. They were never on the screens, never on the doors. All of their own procedures were failed. How was I supposed to know the details of the reporting restriction? I couldn't. It was impossible for me to find out. So what did I do? I went and I didn't report on the current proceedings. I only read information which, according to my training and according to the laws on the website, no judge has any power to put reporting restrictions on information that's already in the public domain. So to all of you standing outside court today, to all of you watching this, we soon find out whether free speech and press journalism is dead outside British courts. We now find out whether we have a corrupt legal system. I should be walking out of here as a free man, with all charges dismissed as not guilty. If I had 12 members of the British public as a jury, that's exactly what would happen here. But we've all witnessed that this is more about politics than about law. This isn't about what I've done, it's more about who I am. I hope and I pray that the judge in this case restores not just my faith in the British judiciary system, but every one of yours. I want to thank every single one of you for supporting me. I hope to God I'm walking out that door today to go back to my children. Thank you, everyone.